Good morning, and may it please the court. My name is Peter Afrasiabi. This court should reverse because why? That is what this program will tell you, the nuts and bolts of preparing for an immigration appellate argument, so that you know what to say in the few mere minutes they give you. Welcome again, my name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my law students, focusing primarily on immigration appeals, as well as classes on advocacy and persuasion that I have taught over the years. I have litigated well over 150 appeals, probably closer to 200 at this point, and probably close to 100 of them have been immigration appeals. This program is based on that experience arguing immigration appeals to federal judges under a very limited time clock. Now, I have also taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is a nuts and bolts appeal program, one to get you ready to argue your immigration appeal. When you are done with this program, you will have a roadmap to prepare for your argument, a structure to get your argument going, and multiple tips for a successful argument in terms of managing the record of your case, the judges you will have to endure, and tips to gain and maintain your credibility as an oral advocate. We will use a couple of video clips from some immigration appeals I have argued to demonstrate some of these tips and tricks, and then you will be ready to go and conquer your immigration appeal. But first, and briefly, I want to tell you about our advocacy program series and our Curious Lawyer series that we have created for you. On the advocacy front, there are several distinct advocacy programs on persuasion and advocacy. Here are 5 specific ones. First, Art of Persuasion. Second, Dangers of Over-Aggressive Advocacy. Third, Advanced Advocacy of Credibility and Storytelling. Fourth, To Please, Prove, and Move, a program on ethos, pathos, and logos. Fifth, a specific program on storytelling for lawyers. Those nuts and bolts advocacy programs pick up on some of the topics you will see today. Turning to the Curious Lawyer series, that is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. We take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore, and to better educate you about legal areas you may not know. For example, we have done programs on dog law where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law to even trusts and estate battles over dogs. And of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program where you will see fascinating legal topics related to the CIA, secrecy, and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, "I can neither confirm nor deny." You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park, where, due to a combination of the Sixth Amendment and the subsequent federal districts that were created by Congress to sit over the nation, whether that, in fact, has actually yielded a sliver of land in our famed Yellowstone that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. So sit back and let's get going now on getting you ready to argue your immigration appeal. Let's do a quick overview of our agenda today. We are going to address some very useful nuts and bolts tactics and strategies, some do's and don'ts, as it relates to arguing specifically an immigration appeal before your panel of judges. We will look at how you specifically prepare for that oral argument, with a multi-step process that you can employ to perfect your preparation process for arguing your appeal. We will also look at how you can frame your arguments in manners that are most likely to succeed. This comes from my experience, litigating hundreds of appeals and close to or more than 100 in the immigration area specifically, and my experience over the years in terms of argument, framing that is most likely to appeal to the widest swath of jurists. We will be looking ultimately at credibility can maintain your credibility, and things you need to avoid doing to lose your credibility, which is critical to pressing your appeal successfully. This is ultimately an exercise in ensuring that you can be the best advocate that you can be and show up with dynamism. We will also take a look at the difference between live-in-person oral arguments and remote oral arguments, along with some tips and tricks to make your remote oral arguments better. And in all of this, we will take a look at some real-world examples. So let's get going. The first slide here is about your audience and goals, the role of an appellate court. This is the most critical factor. Of course, in any oral advocacy is understanding who's your audience. If I go home and have an argument with my wife, and I start citing to her precedent about our prior arguments, and start talking about the appropriate policy ways that we should be interpreting how we discuss things with each other, I'm going to be on the losing end of that argument in that sort of a scenario because there's a different type of audience that requires a different way of speaking at issue. For us, the difference between trial courts and appellate courts is critical as the first step in your immigration appeal. The first slide here is about your audience and goals, the role of an appellate court. This is the most critical factor. Of course, in any oral advocacy is understanding who's your audience. If I go home and have an argument with my wife, and I start citing to her precedent about our prior arguments, and start talking about the appropriate policy ways that we should be interpreting how we discuss things with each other, I'm going to be on the losing end of that argument in that sort of a scenario because there's a different type of audience that requires a different way of speaking at issue. For us, the difference between trial courts and appellate courts is critical as the first step in your immigration appeal. Trial courts exist to make facts, to find facts, to decide who wins the case. Where's the righteousness between those parties? That's what the finder of fact is there for. And that's what the trial court is there for. That, of course, frames and develops the nature of your advocacy. But when you're on appeal, you have a different audience. You have an audience that's focused on different issues. The appellate court is not focused on figuring out who should have won in the first instance, who's the ultimate party with righteousness. Rather, the appellate court is charged with establishing law for an entire jurisdiction of people and assessing whether if there was an error in the case before was it a prejudicial error. And in so doing, it's tasked with giving deference to the agency or lower court. This difference is seen in the standards of review, so an appellate court may well look at a set of issues and conclude how, had I been the trial court, I would have come to a different conclusion. But nonetheless, I'm going to affirm because what the trial court did, well, it didn't exceed the bounds of reason. That's an example of a standard of review, such as abuse of discretion, which governs so much of your immigration appellate work. This means your audience is focused on a completely different set of issues, different headwinds in terms of systemic policy issues. Those cardinal pillars to the appellate realm that you're in now necessarily frame the nature of your audience, what they're thinking about, what they're looking for. And this, of course, dictates the nature of your advocacy and what you should be saying. So audience is going to be well-versed in the case facts and the law. They're focused on making law for a jurisdiction. They're focused on whether there was a clear error below that prejudiced someone. They're focused on the standard of review and how much deference they should be giving. All of this confronts, as you see here, that when you get up as an advocate, the key point is this is not a time to give a speech. This is not the emotional presentation that you made to the IJ to stop removal. Rather, you're involved in what is really a dynamic, rapidly shifting ping-pong discussion. A conversation, a dialogue, answering questions, needing to pivot from your answers to make your points all in a very abbreviated amount of time. You don't get more than 10 minutes. Sometimes you get 15. It's rare to ever get any more. And so you need to be able to manage that dialogue. Answer questions, not just from one judge who may be looking at only one issue, but from 3 judges in 3 different perspectives, all of whom have spent a significant amount of time working up your case with their law clerks and are ready to engage with you on your oral argument. In the next hour, we're going to get you ready to do that. For immigration appeals in particular, this is a very divisive area among judges. It's a very policy-rich area for disagreement, and it is obviously a very political area in our broader society. The result is that these cases are very much panel-driven. What does this mean for you as an advocate arguing your appeal? Starting in the beginning, unlike when you were in the agency, you do not know who your 3 judges are until about a week before oral argument. Double-click on that for a second. When you have a case and you were assigned to your immigration judge, you know that judge. You know the issues that may appeal to that judge, and you know the hot-button issues that may alienate that judge. You can tailor your advocacy as a result, but on an appeal, you cannot do that. So the first pointer is, before you get to oral argument, think about what we are talking about here in terms of how you frame your written submissions. And the point that comes from not knowing your audience is that as you prepare your briefing, as well as your argument, you want to appeal to the widest range of jurists possible. Given my experience over 2 decades litigating numerable immigration appeals, one of the conclusions that I have come to, and I regularly teach in advocacy classes, is that arguments need to be framed as much as possible through prisms of process-oriented failures or procedural breakdowns in distinction to substantive fairness arguments. The reason for this is that those types of process-oriented arguments have the greatest likelihood of appealing to jurists on both sides of the political spectrum. And you need to prepare for your appeal by focusing as much as possible on legal error. The systemic deference to the agency, coupled with the standard of review, means you routinely get panels who, as an immigration lawyer representing the petitioner, you would think, given they are more left, leaning would be far more favorable, but the standards of review constrict what they can do. And so you need to, if you want a hope of convincing these jurists to sign on your case, have your issue framed as one of law as much as possible, as opposed to arguing about an improper exercise of discretion below. In federal appeals, you have a 3-judge panel. Of course, this is unlike your normal arguments where you have 1 immigration judge. Before an oral argument in the Court of Appeals, you don't know who your panel is when you write your briefs. You learn your panel sometimes a week before oral argument. Sometimes, in the case, for example, if you're arguing the Federal Circuit Court of Appeals or the state courts here in California, you may only learn your audience the morning of, so you'll have 3 of them. You're going to get aggressive, detailed questioning. Part of the reason you're getting aggressive or detailed questioning is you've had 3 judges look at this case with law clerks, all of whom are smart top grads from top law schools. They have been burrowing through your case, looking how to undermine everything that you've argued for. They are trying to figure out if you are wrong. You will be engaging with these people. And it's been my universal experience that the panels are pretty consistently versed in the facts and the law. You never are showing up where you have a real informational advantage over the judge. Sometimes in trial court cases, of course, with busy court dockets, one has the feeling as an advocate that the trial courts may not have had as much time, and they may not be aware of certain facts or law in your case. But when you do your immigration appeal, that is not the case. This counsels for the first practice pointer: prepare, prepare, prepare. It's a dialogue, it's a conversation. You're answering questions, it's not a speech. The error that many appeal advocates make when they're not used to arguing in the Court of Appeals is they show up with a little speech as if they're a politician, and they've literally written up a 2 or 3 page single-space document, and they're ready to give a speech to the Court of Appeals. If you've done that, you're in big trouble. Rather, the dialogue is more akin to the metaphor of being on a river. You're on a boat, you have some control over your boat, but when you hit the rapids, the river is going to kind of take you wherever it's going to take you, and you don't have a lot of control, even with your paddle. Once you hit some part of the river, you can paddle hard and pivot and turn and go somewhere else, but within some externally dictated bounds. That's a basic metaphor that works for a Court of Appeals argument. The court's going to ask you questions. You may be answering a question, and before you even can get back to your point, another judge asks you another question on a completely different topic or area, and you're now bouncing somewhere else. Sometimes you get question stacked on question and can't even answer the first one before being assaulted with another one. Hence, you're engaging in a game of ping pong. But as you bounce around, you have opportunities to pivot and move your argument back to make your points. You can only do that if you're well prepared, though, to make those points as concisely and briefly as possible. Key point now. Answer questions directly. Never evade. It's particularly important in the Court of Appeals, where you have such limited time to make your points. Regularly, I watch and a lawyer does the lawyerly thing and not answer a question directly because they're nervous about the implications of simply saying yes or no, and they give some long-winded answer. It invokes the ire of the court, and the court says, I want a direct answer, is it yes or no? And once you've done that, you've burned up your clock with a judge who's upset at you. You've wasted time unnecessarily, and the better practice is to answer the question. If you don't like the answer, and there's a reason why the question isn't a great question, you can say yes, but that is not the issue, Your Honor. Let me explain. But if your response is to start reframing the question in your terms, you will upset your panel. They will make an example out of you in front of the court. You'll be losing your credibility, and you've just blown 30 seconds, which when you only have 7, 8 minutes on your opening oral argument portion, that is a massive percentage of your time to give up and to have lost some credibility. Remember, I mentioned it is a ping pong game, and you are often feeling like a ping pong ball getting bounced around. In this immigration argument, you have to sometimes manage stacked questions, and you have to deal with being interrupted. Let's watch this clip from an immigration appeal I did where I face a barrage of questions where one judge won't even let me answer the other judge's question before stacking his question again and again. You will see at least 3 stacked questions, and we can then talk about staying calm under pressure and how to manage it.
And that's why it's so
But
important.
that's not how we do this. I mean, I guess I'm fundamentally I'm worried that we should cut you off at the pass, because if we opened up the door to this, we're opening up a door to anyone come in and claiming all kinds of new mitigating factors that weren't presented before. And the fact of the matter is, it doesn't even matter.
I mean, you've got some evidence, for example, the grand jury testimony, that most immigration lawyers will never be able to even see unless their client had previously been convicted and that information was turned over in discovery by the government.
I mean, let's take a different hypothetical. Let's say that it was murder. And then the defendant, we all agree, murder is a particularly serious crime. There's no debate about that. And then 5 years later, they come in and say, well, he was abused, all these other mitigating factors. I think my response would be, it's all irrelevant. Like, the fact of the matter is, he was convicted of murder. I don't care that there were 100, mitigating factors. That's not the legal analysis. Can you show us where a court has looked at this? I'm just trying to get you out of the gate here. Like, where has a court looked at this and said, we're going to dig deeper underneath the crime and look at mitigating factors to determine whether it's a particularly serious crime?
Well, I think that's what Francisco and Bear v. Barr say.
I don't think it says that at all.
Well, I think what they've said is it's not mechanical. You don't just look at the label of the crime in the sentence and say done. And so
Yeah,
that
but
means
you look at the crime. Where have they said you get to look at mitigating factors?
Well,
I think if 2 people are convicted of the same crime, then those things come across and we analyze them in the same way. We don't say, oh, this other person has all these other mitigating factors, so therefore it wasn't particularly serious. Where's the case that says we can even engage in this analysis?
I think Bear v. Barr, pages 964 to 965, says nothing in the definition of a particularly serious crime limits the scope of permissible evidence. And I think...
So you saw there multiple questions without even a chance to answer. Stacked question also. It is seriously frustrating. And your clock is dropping the whole time. This means when you get a chance to speak, you have to be brief and specific. And this is exactly why long-winded answers do not work. That is a key tip out of the gate. Go for brevity, always, so that when given even a second for air, you can give the answer. The process discussed in this program will get you to do this. We will come back to that case to use some other clips shortly. The next slide is effective arguments. What's our end goal? Our end goal is that you will be able to grab the attention quickly of the panel before you're interrupted. You'll get a small amount of time to get their attention quickly out of the gate before you get interrupted. But you're going to be interrupted, so you need to have distilled your argument to its core points to get their attention. Outline what your core argument is. Right away, be prepared to spend most of your time answering questions and pivoting to make your points in response to the questions. This again means if you've come with a speech, you've shown up at the wrong place. Have the key points ready at your fingertips to work in as opportunities arise. We'll look shortly at a useful example of what to prepare for your podium materials. Be ready to discuss the key cases in your appeal. The court will know them in great detail. You need to know them inside out, and you need to be ready to have a genuine dialogue about the case. What were the facts of the given cases? What were the holdings? What were the dispositions? And how those engrafted onto your situation? Be ready for hypotheticals that are going to test the bounds of what you're arguing and what the ripples may be in the law for future cases. Be ready to discuss the procedural implications of the positions you're taking in terms of what it means, for example, on remand for the court to do. And ultimately, you need to stay cool under pressure. So now let's get you prepared so you can stay cool under pressure. The first way you get there is by maintaining your credibility. The kitchen sink approach is bad. If you show up at oral argument and you intend to argue anything and everything, and you intend to point out that the agency simply couldn't get anything right, everything it did was wrong, then you are in a bad place out of the gate. This quote from Supreme Court Justice Robert Jackson in the 1950s perfectly encapsulated this cardinal principle of appellate advocacy, both for brief writing, but also for oral argument. The quote being legal contentions like the currency depreciate through overissue. The mind of an appellate judge is habitually receptive to the suggestion that a lower court committed an error, but receptiveness declines as the number of assigned errors increases. Multiplicity hints at a lack of confidence. Multiplying assignments of error will dilute and weaken a good case and will not save a bad one. So the point here is, don't just start riffing on the law. Don't get up and start arguing that the agency seemed to have just been confused, couldn't get anything right. If you do that, you will have blown your credibility instantly when you get up at oral argument. In preparing, you need to have distilled your case down to its one or two maybe key points upon which everything hinges as to why the agency erred and your immigration case needs to be reinstated. There may have been several arguments in your briefs, but oral argument is not about regurgitating all of them. Pick one, maybe two, and the best one to win on, and that is where you put your energy in your scant few minutes. This maximizes value of the time you have and demonstrates your credibility. You know your best argument and you focus on it. You need to be there to make the key argument upon which you can win and have their attention on that key argument so that your core argument gets 10 minutes of attention, as opposed to spreading yourself out over 5 or 6 arguments, none of which are going to have much traction when they have a minute each. This is one manner of preparing your argument to get to your best point, and then start double-clicking on that argument. This slide here is for those of you who are math-oriented. I call it the currency of credibility chart. You can see that on the y-axis we have the assignments of error. That is the number of arguments you are making. And on the x-axis we have the idea of receptivity to any given particular error. It's a pretty simple equation. As you increase the number of arguments or challenges or claims that the agency couldn't do anything right, the Court of Appeals has an ever decreasing receptivity to the idea that they did something wrong. If you focus on a number of arguments or errors, there's a greater receptivity to focus in on the fact that the agency may have made a mistake in this one particular zone. I like to share this quote because I think it is important that you recognize in your immigration appeal, the outcome is not foreordained by the written briefs. There is a chance to win. This is from the United States Supreme Court, where it is even harder to turn an appeal from the written submissions. Given the sheer number of justices on the court, the massive amount of assistance they have, and the few cases they take every year, compared to your immigration appeal court. So what he is saying here for the Supreme Court really doubles or more for the Court of Appeals that you will be in. Lawyers often ask me whether oral argument really makes a difference. Often the question is asked with an undertone of skepticism, if not cynicism, intimating that the judges really have made up their minds before they ever come to the bench. An oral argument is pretty much a formality. Speaking for myself, I think it does make a difference. In a significant minority of cases in which I have heard oral argument, I have left the bench feeling differently about a case than I did when I came to the bench. The change is seldom a full 180-degree swing, and I find it is most likely to occur in cases involving areas of law with which I am least familiar." End quote. That means you certainly can win and have hope to win. This is why preparing properly to use your scant minutes most effectively is so important. We talked about this before a bit, but as the gateway to our specific preparation model, I want to revisit it as it is an important orienting principle. Focusing on procedural and process-oriented failings of the court below rather than the substantive unfairness of what is befalling your immigrant client is a better all-in approach. If you get the judges that care about the substantive fairness, then that will be in your briefs and part of your argument anyway. But you want to win your appeal, and you don't know who your 3 judges are, so you want to appeal to the widest range of jurists. Finding procedural errors is one way to do that because regardless of political orientation, all judges in my experience are frustrated by broken processes in lower courts or in agencies. For your preparation then, think about the different arguments in your brief. And remember, you are stripping those arguments that are in your brief down to 1 or 2 arguments that you will a layer of complexity that is really a procedural process-oriented failure as opposed to something being substantively unfair. Let me give you an example, being substantively unfair. Let me give you an example. If the agency ignored several arguments you made or ignored key facts, that is the type of process-infected problem that has a greater likelihood of appeal to a higher court when compared to arguing that your set of facts shows persecution or likely torture, when the agency said it did not. Let's now break down the preparation process given this larger framework we have developed. Part 1 of your preparation process so that you are ready to stand at that podium and shine requires you to go back to your briefs and your record and do a review period. What do I mean by this? I mean you have to absolutely know your record cold period. I'm not saying you have to memorize the administrative record, but there are 5, 10, 15 different specific pages in that record upon which your arguments will turn. It would be rare for there to be more. Frankly, it's normally less than 15 and is closer to 3 to 5 specific pages that actually matter. For example, a specific answer to a question that was misinterpreted, or a specific part of a country condition report that was ignored. You have to know that record, which requires you to go back to the beginning and read the record from the end of the administrative record to the top of it. Then go back to your briefing and read all of the briefs carefully a couple of times period. I actually recommend doing this starting about 2 months before oral argument and simply going back to your briefs, which by this point are probably several months stale. Read them all from beginning to end and make notes from them about arguments that seemed good, points that don't seem strong, and then let that sit in your mind for a while before you come back to it again as you get closer, around a month out, and do it again. This is an incredibly invaluable part of the preparation process because you would be amazed by how many things you did not pick up on during briefing that this process lets you pick up on when you have allowed the briefs to brief be in your mind and filter for several weeks. When you are done with this process and you start getting ready to dive deeper, you should have a rough outline written in terms of your arguments, the counterpoints, and the relevant portions of the factual record that matter, and the 5 to 10 cases that may matter. Part 2. Now, generally starting around a month or 3 weeks before oral argument, you want to do a deeper review of the facts and the law. This means you are aware of how you argued those facts and law in your briefing, but you need to go back to your record to understand exactly what the facts are and make sure there is no improper spin in the record. And you need to go look at the key case law again and unpackage it very, very carefully. What exactly did the court hold? What did it not hold? Have you stretched the law too far? Let me give you a specific example of how it is useful in this preparation process to organize case law on a given question. Start by thinking about the idea of a spectrum chart, a line graph that is basically, I always organize my case law along the spectrum from cases that are beneficial for me to cases that are adverse to me, and have it separated along the spectrum so that I can very, very specifically get to terms with the cases that are good compared to the cases that are bad, and specifically where my case fits in there. Let me give you a specific example now. Take an immigration appeal where your client was removed due to a criminal conviction and then tried to reopen the proceedings because of a change in law as to the removability given that conviction. The agency denies the motion on the basis that the client did not move with enough speed and was not diligent enough. You have made the argument that the agency erred and your client really was diligent. There will be 5 or 6 cases that between you and the government really illuminate the spectrum that I'm talking about. Cases where a petitioner was found to be diligent in cases where the court concluded that there was no error below in finding a lack of diligence. For this preparation process here, you specifically have to understand exactly what the facts of those cases were, line up the cases on a spectrum, and be very, very clear about how your case compares to the good and bad cases, and what your best arguments are to fit within that portion of the spectrum you need to be on. You will have done this to some extent in your briefing, but it is existing at a much higher level there often. And as you prepare and further narrow this case down, you want to get to the point that you have identified the single best case on that spectrum for you, so that you can give that to the court and focus the court on that case oral argument. At this point, you will have developed a general sense of your outline, the best argument that you are going to focus on, which arguments you will let stand on the briefing, and you are focused on the best facts and cases for that argument you really want to focus in on, giving your most limited resource in an immigration appeal: time. And so you want to know, what do I bring up to the podium? Do I bring up all of the briefing, a pile of case law, and my 600-page administrative record? Do I bring up a 4-page Word document that I have drafted up of the argument I intend to make? I'm not saying not to do those things, but what I have found from experience and in the teaching I do of law students getting them ready to argue appeals, the best materials to take up are far more succinct and narrow. If you have prepared fully and properly, you will find you do not need the briefs, the piles of case law, or the administrative record. There is a substitute that you can have for all of that at your fingertips to be able to manage questions quickly and efficiently without having to rifle through hundreds of pages of documents. Of course, you need those documents there just in case, but you don't even need them at the podium. The result is for this phase of the preparation. When I am done, I approach the podium with essentially one piece of paper and maybe 1 or 2 small documents in there. In other words, I develop what is my core argument, what are the most salient and relevant facts with the specific citation to the record, and I will print 1 or 2 pages if it is critical to be focusing on a specific question, an answer, or perhaps a specific statement in an I-589. And I also have specific shorthand notes that worked for me in terms of the good cases, the bad cases, and what they held and said, so that I can look at this very quick reference document I have in front of me if my brain freezes when asked a question. Let me show you a photograph of an actual form of material I take up, and then I can explain to you how I create it in the process. This I have found is the most beneficial method of approaching an immigration appellate argument, and it is the one I teach my advocacy students. Here you can see what looks like a large piece of paper that I've divided into 3 sections. I actually take a large 8.5 by 14 envelope and open it up so that it is a larger piece of paper that can then fold back like a folder. I divide the left side as being the side for my key facts. The far right side is the key law, and the middle is the key argument I want to make. Let's talk about each 3. On the right, I will list the most relevant facts in the record that really matter with the actual citation to the record. So let's imagine your immigration case really turns on some statements in a country condition report, a statement in the I-589, and 2 or 3 pieces of testimony at various locations from the record. What I would do is write those out on the left side and put down the specific page number of the record. Those are the key facts that matter to my argument, and I include the good ones and the bad ones, obviously. The reason for this is that you often find in the preparation process that there may be a very specific fact in the record that was obviously briefed by you, but has lost some significance within 200 pages of briefing period. And so you want to focus the court on that fact heavily and really have them telescope in on it. You won't even need to look at this document in all likelihood, because you will now be very prepared to discuss that fact. But this is there as a crutch in case you get a question from the court about one of the key facts and you need to be able to discuss it. Let's now go to the right column there. I outline the law. What I actually do is either use literally large 3.5 by 5 post-it stickers like that, or index cards, and I stick them to that piece of paper. And each index card is a specific case where I simply have the name of the case, the exact facts of the case in very shorthand form, and the exact holding of the case. Now I will have the actual full case also in court in case I need it highlighted and marked, but this is the core information that really matters, and I have it all there in case I get a question from the court out of nowhere about a specific case, which can happen where you are asked about case X versus Y, and it's not even the issue you were talking about, and you need to jog your memory really quick, and that is what this crutch is for. In the middle, I have my fundamental key arguments I want to make. The core of why the agency erred and why you should win. I write that out in a few sentences for each specific argument I may be wanting to make. And I have it there because it is useful in case you are fighting along with the court on one argument, you are running out of time, and you need to pivot to your other main argument, and your brain just simply freezes. This is normal, but you can look down quickly and it jogs your memory, and then you are off and running and talking. At the bottom, have what you can see there in the middle, what I call firewall. These are must-say things that I have to get out to the court no matter what. Essentially, this is for the category of stuff that I realized after all the written submissions that there is a finer point to an argument or a more critical fact that was not just illuminated enough, I feel. And so this is something that simply I have to get to the court's attention and demand that they listen to this point. And I write that there just in case you are taken immediately with questions to somewhere else in the appeal, and you don't get a chance to even utter those points. Given the nature of the questions period, this is there for me to, at some point, say, I see I've used up all my clock answering your questions and I have 30 seconds left. I must make the following 2 points. Part 4 of our preparation process involves doing moot courts. Why is this important? It lets you get practice answering questions out loud from people who will not be necessarily as familiar with your record and who have fair probing questions, period. It also lets you see the strongest and weakest points of your argument so you can actually finesse how you say things to frame things in the best possible way. Here are the questions you want to think about in terms of being able to answer and demand that people push you on in your moot court preparation. What is the best case for you? How do you address the worst case? What exactly are the facts that your case turns on? Critically, what exactly did the agency say and what did it not say? What is the exact error below? What is the standard of review you confront? If you really have the time, an incredibly valuable part of the preparation process that I require all my students to do every year is to actually argue the government's case. That is, after doing a few moot courts on our appeal, I have them put on the hat of the government, go back through the briefing, figure out the best argument for the government, and then show up and do an argument on behalf of the government and take questions. This is incredibly valuable in terms of seeing both the weaknesses to your case and the strengths to the government's case. But also, it often helps illuminate perhaps slightly better arguments the government could make, which were not in the briefs, but which may show up at oral argument, or could be the subject of a question from a judge. It's also incredibly valuable to make sure you have not, as the saying goes, drank the Kool-Aid. If you have not been in this court before, then I would recommend going to the Court of Appeals sometime before the argument just to see the physical space, the courtroom, stand in it if it is open. This is really useful just to have your physical bearings in terms of the geography, so you are not unnerved on the day. And I also would recommend, if your case is on a Tuesday, Wednesday, Thursday, for example, watch online or in court even if you can, the same judges you will have handling their cases on a prior day. The messenger matters period now, what that means is that not all of us are innate advocates in terms of doing appellate oral advocacy, for example, or trial court advocacy. Not everyone is Clarence Darrow. We are all different in our different ways. But that does not mean that we cannot all be dynamic speakers. Being the best massage messenger for your case means being true to your advocacy style and not trying to fake anything. That is the most important tip I can give you in terms of being a dynamic messenger. Now, emotion, of course, is critical to win arguments, but you have to be careful using it at the Court of Appeals, because this is not a place that is swayed by feelings of emotion or sadness for your client and what they may endure if returned to their country of origin. At the same time, you cannot be a robot, and a board decision maker is a disaster for you. So your delivery cannot be a substitute for substance. But the substance alone delivered as a robotic speaker cannot also be the sum total of your advocacy. How do you connect with this audience and show the right level of emotion and passion for your case? You have to be yourself. If you try to perform as some vision of an advocate, sort of like you try to act like Tom Cruise in A Few Good Men because you think that's what you should do, and that is not your natural persona, the judges will see through it. You will not be able to maintain it, and you will actually then damage your own authenticity and your credibility. So even if you are not a great natural speaker, you may have a lisp. English may not be your first language. It does not matter. You simply need to be there to make your argument. Be brief and respectful in how you do it. Make eye contact with the judges because that matters. Answer directly, and simply be the best version of yourself that you can be without trying to be something you are not. What are the first words you want to utter out of your mouth? That is, in that middle section of the podium materials I showed you, what is your core argument? The preparation process we have gone through will get you there. And this is a rubric I use for myself all the time, and I require my students to use it to help distill our argument down to its essence. It is also nice to have your first few sentences in your mind and ready to articulate before you get questions so you can get rolling, while at the same time not having to read off a piece of paper. So like I started this whole program by saying good morning and may it please the court. That is how you begin. Good morning, and may it please the court John Doe on behalf of the petitioner. This court should reverse the BIA because its social group holding is wrong as a matter of law under the case of X v. Y. That is the core argument or crux of a given appeal, and so you need to be able to articulate it in a sentence. Whatever your issue and argument is, at its root, you can articulate this at a high level in a sentence, and then be able to discuss it and explain it within a couple of minutes. You have to think of this as being the equivalent of an elevator pitch. Now, many times I'm told, Peter, you don't understand. My case is far more complicated. I can't get it out in a couple of sentences or even in a paragraph. It is simply more complicated than that. My response is always the same. No, it's not. If you are feeling that, then you have not distilled your case and argument down to its essence. Remember, you were here to show up and make an argument. You are not here to regurgitate your briefs. You are not here to walk the court through all the rules and law as if you are writing out an outline in law school of what the law is. Everyone already knows what the law is, the key cases in your briefs, and where the collision of the parties is. This is about your argument. So if you remember from law school the IRAC method, this is all about the A part of that. And this is what I have written out ultimately in my podium materials. And a quick aside, the podium materials will change drastically from when I start working on them a couple of weeks before argument, even up until the night before. It is a process of refining and refining and refining until you get down to the root essence of your argument. Let's take a listen now to an argument I did in an immigration appeal where I used this model to frame the argument right away. Quick background. This is a motion to reopen for ineffective assistance that was denied by the BIA. The underlying arguments to avoid removal were that the crime committed that had a 47-month sentence was not a particularly serious one, and that an argument under CAT existed. And the argument was that important material was omitted from the motion to reopen that may have altered the outcome.
Thank you, Your Honors, and good morning, and may it please the Court. Peter Afrasiabi on behalf of petitioner who is present with me, Ms. Loamsajan. Your Honors, this case fundamentally presents what's a procedural issue. It's not a referendum on whether the government's characterization of her is right or her characterization is right. This is a procedural question about whether the BIA, on an ineffective assistance of counsel motion, used the wrong standard. And our submission is it did, because as a matter of law, the ineffective assistance of counsel motion established a plausible case.
There you go. That is 42 seconds. You can make your core argument fast once you have really distilled your case to its essence. Let's now take another example. You get a question and you need to answer directly. This small interchange is important to illustrate the need to let a judge finish his question, even when you know what it is. He speaks slowly and elliptically. You have to just wait, even though your mind is wanting you to interrupt. Then, because you have done this program's process, you have your few key facts and record sites, there it was, my Exhibit J document that I really had to talk about, and that was central on my facts and notes of points to address. Ultimately, here is what I have found, by and large. This detailed methodology for the preparation process itself gets you, so you do not need the materials.
Third thing, I can't remember what the third factor was. And it looked to me like the evidence that you are complaining about would have been cumulative in the sense that it would have fleshed out in greater detail the nature and extent of her cooperation. But I'm having a hard time understanding why that would have made an impact on the decision when the board had previously considered that.
I'll tell you exactly why.
Okay.
And there's two, PSC and CAT. With respect to PSC, the immigration judge in the original trial said, I've looked at the plea agreement, I see her sentence. Tentatively, I find this to be a PSC. Counsel, it's not set in stone because the calculus under Frantescu-Bear v. Barr is never set in stone. It's a flexible calculus. And what she told him is, if you want to change my mind, I need evidence. And the evidence that wasn't given that bears directly on this, and that statement from the IJ is at page 847 of the record, is, and really the key evidence that I would ask you to really focus in on is, this Exhibit J at page 267 of the record is the government's down.
So now I will play again part of that same appeal. I argued to give an example of being bombarded Bonnie stacking questions, this after the one you already saw, where you are losing over a minute or two, just to the stacked questions, then being interrupted and having to politely get a chance to answer. I did not invent this, of course, but did see it done once by a famed appellate advocate, and thought it quite a useful way to address the endless questions that deny you a chance to even speak, to address being treated like a piñata.
There we have evidence that we can look at. The emails that the attorneys were given show at the time of the underlying criminal prosecution, there were threats that were directed back to family in Thailand.
There was a threat, right,
Yeah.
by the fellow inmate, and the Bureau of Prisons took action to move your client so that that threat could be neutralized. But the board also looked at the fact that the Thai authorities were stepping up their enforcement of sex trafficking rings. There had been no harm to her family in Thailand. I mean, that was all before the board. So
It's true, Your Honor.
What difference is this more fulsome evidence going to make in the assessment of particularly serious crime?
Well, I'm talking about CAT. The reason this evidence
Even
is...
cat relief, if there's no harm has befallen her.
Well, being threatened counts as harm to begin with.
No, but hold on. You can't just come in and say, oh, we have new evidence of a threat. You have to show that it ties to the Thai government. There's nothing in the record about the Thai government not protecting her.
I disagree, Your Honor, for this
what?
reason. Let me, and I can explain it if you give me a couple of sentences. When the co-defendant threatened her, that fact was not given in the original trial. Judge Frank said she has confronted threats, and similar co-defendants have confronted threats. That is very important because the threats were going also telling her your family back in Thailand can be attacked. Now, the original trial, that's the causation issue that was missing in the original trial.
She didn't testify at that trial. Are you talking about the co-defendants that were ultimately convicted in the case?
No, I'm saying at her original asylum trial, the causation evidence that ultimately was missing.
The merits hearing on asylum.
That could bridge. Yeah, I'm talking about the torture.
When you said trial, I thought you were referring to the
Sorry,
trial in
no.
Minnesota.
But more fundamentally, you said give you a few sentences. I gave you that. I still heard nothing out of your mouth that tied it to the Thai government. Threats from co-defendants does not count. You agree with that, right?
I would agree with that, but there is evidence with respect
Well, I'm
to
waiting.
the government.
I'm waiting.
Yes. The police worked to smuggle women out through the passport lines with the criminal gang. That's in the record. The reason that's important is because before she was ever in asylum proceedings, when she said, I'm worried because the police, which is in the ROIs, that weren't given. The police work with the gang. That connects it. The police are in league with the criminal
The
organization.
Thai police.
Yes. And they work to smuggle the women out through special passport lines. And so when she's testifying in the criminal case, before ever being in an asylum proceeding where one would know that this stuff could matter about Kat, it's really important that she's telling the government, the police in Thailand work with the gang. And so then when a co-criminal defendant says, we're going to threaten your family back there, of course she's worried, because the police do work with them. And that's the evidence that was never given in the original trial.
I asked for a few sentences as a polite but firm pushback on the stacking and interrupting. I have only done this maybe once before. I did not invent this, of course, but did see it done once by a famed appellate advocate, and thought it quite a useful way to address the situation, which is rare, where you find endless stacked questions that deny you a chance to even speak. This again is to address being treated like a piñata. Now you better answer fast. And there I did not get my thought out before another question came, and so got pressed again, by a judge who would not let me the first time finish. Is there a lesson here? Yes, I should have started with the police and passport and then backed into what I said first on causation. That may have been a bit cleaner, I think, than the chronological route I was going. But it nonetheless allowed me to get my point out. And critically, if this is a true piñata situation, you have to be firm and polite, but you have to get an answer out too. One additional quick note, you have to be very clear on what exactly you want. All too often in briefs, you simply make a whole bunch of arguments. And in that final section, you say reverse. But the court is very focused on exactly what you want. Is it an outright reversal? Is there a remand? Does the agency have to do something if the court reverses? Think about this specifically because this is a very typical question you will get. Now, like I said in the beginning, you will have normally at most 10 minutes of argument time. You will want to reserve 2 or 3 minutes for rebuttal, which means your main argument really is only 7 to 8 minutes of time. What do you do in your rebuttal? You don't simply do a 2-minute version of what you did for 7 or 8 minutes. You want to focus in on where the court's questions went with the government lawyer, the types of concerns the court had that may give you an opening to highlight, and focus on something that they were troubled with respect to the government's argument. So this means when the government makes its argument, pay very, very close attention to it and take notes along the way, identifying 1 or 2 key points you want to make in your short rebuttal time. Let's take a quick look at this chart in terms of some do's and don'ts. Always answer directly, avoid the evasive lawyerly answers to try to avoid a question period. You will simply upset the court, the judge will call you out on it, you will have to ultimately answer the question, and you will have lost valuable seconds and credibility unnecessarily. You will make your argument and start receiving questions which may or may not be germane to the specific point you are making. You need to then answer those questions even if they are off topic for where you were. And once answered, you need to just simply pivot back to where your argument was to get to your main points you were trying to make. Don't just answer a question and stand there waiting for the next question. In your preparation process, think about the narrowest way that you can win, as that is often the most preferable option for a court to give you a victory, which can be done without having to change the law for an entire jurisdiction. Keep your credibility by citing facts and case law accurately. When you do get a question, pause as the judge starts asking it, and then listen to the question and let the judge finish before you start answering. Finally, if you don't get many questions and you've made your key points in 5 minutes, don't just keep talking to fill the time period. If you've made your argument, be confident, sit down and reserve even more time for rebuttal. We are going to do a quick pivot now to remote oral argument issues, which raises a host of new issues. But let's start with a fun look at what not to do, specifically to not have sound enabled if you should be on mute. We take this one from our Supreme Court and one of their most embarrassing moments when remote arguments began after the COVID situation began. Take listen to this clip of oral argument as we hear the flush in time that embarrassed the 9.
And what the FCC has said is that when the subject matter of the call ranges to the topics, then the call is transformed, and it's a call that would have been allowed and it's no longer allowed. And so I think that the content of the call is different here.
Excuse me, I guess a technical issue.
And with the FCC.
So you don't want to forget to mute. That much is clear from that episode when one of our justices was using the toilet while on an oral argument with counsel. Let's now break down for you some remote age tips for oral arguments and appeals, so you have a handy checklist. Now we will take a look at a chart of some do's and don'ts for remote-based oral arguments in your immigration appeals. It is critical that all external noise sources be turned off, and when you are not on, make sure you hit mute. I also find it very beneficial to pause a little bit longer after you've made your point before pivoting to the next point. You may want to also speak at a slightly slower pace and try to enunciate more than you may do normally, because the absence of being physically present and relying on technology to mediate your voice to the court's ears can require a little more effort. If you are going to be using papers and other materials at your desk to refer to, then I highly recommend putting down a towel or your yoga mat and putting the papers on that, because they make an incredible amount of noise that gets picked up by the microphone as you shuffle through them on a desk. And I highly recommend that you make your argument standing as opposed to sitting at your desk. Have a background that is entirely white or shaded out with those features you can use on Zoom. You don't want the court paying attention to your artwork on the walls. You want them paying attention to your argument. Sidebar note here, one of the things you can do in preparing your appeal is think about amicus support that you could get early on. These briefs, of course, are friend of court filings done by organizations that may be sympathetic to your argument. Obviously, on the immigration front, there are many different organizations that file these briefs all the time. They can be really useful as a strategic tool that lets you focus attention on an issue with broader economic or social issues that need to be contextualized, which may not come out in your briefing as between you and the agency. They can also inform a court as to whether it should publish or not publish a decision, which could be of importance to your client and case. You may also want to think sometimes about allowing amicus counsel to even share some of your precious time period. It is very rare that that makes sense, but sometimes it does. I will give you a quick example of where I actually did this once, and it was incredibly beneficial. This was not an immigration appeal, and it was a patent appeal in the Federal Circuit in Washington, D.C. My client's patent had been invalidated by the trial court based on the argument that the patent lawyer who secured the patent engaged in inequitable conduct with the patent office. The patent, it turned out, had been procured by the United States Navy and its in-house lawyers. The United States government and Department of Defense then wanted to intervene and participate as an amicus party to file a brief about patent prosecution standards and inequitable conduct. I, of course, welcomed this. They asked for some oral argument time. Now, this was a case where I thought it made sense to have the United States Navy basically show up behind me and let them have a few minutes of my time at the podium. It may be rare for you to have the U.S. Navy show up on your side, but there can be times where it makes sense, so think about that also. This brings us to our conclusion in terms of preparing for your immigration appeal. Remember, oral argument can make a difference. Your appeal is not decided before you show up, and the outcome is not guaranteed. This makes preparing the right way all the more important, so that you maximize your chance of getting the panel of judges to take your side. Let's do a quick recap of some of the key points in our method of getting ready to be at the immigration appeal podium. First, use this preparation process so that you can ultimately get to your core argument that identifies the error in the agency instantly. And if you can frame this through a procedural or process error as much as possible, that can also be beneficial in terms of appealing to the widest range of judges. Second and third, answer directly, know your facts exactly without spin, and know the critical case law backwards and forwards. This is important to have credibility before the panel, and also avoid losing any of your precious time being sidetracked looking up a case to argue about what it actually said. And when a judge says, "Show me a case that says what you are arguing, counsel," you can then quickly give it. Fourth, It's also important to know the key argument lines that you simply have to hold and where you cannot capitulate, notwithstanding how aggressive the questioning may be. Courts, of course, love to get you to capitulate so that it can be your concession that justifies denying the appeal rather than them making a ruling on the case. So know your key lines and hold them firmly. Remember, don't interrupt the judge. Simply stop when they start asking a question, even if you're a mid-sentence and you will have to pivot back to where you were when you get an opportunity. Every case has strong points, but every case also has weak points. Be prepared to discuss your weak points, which you may not have done enough of in your brief and will be the laser focus of attention. So be ready for those tough questions, because you did a moot court type process if you were able to, or because you did it to yourself by asking yourself the tough questions. Stay focused on your core points and arguments so that you don't get sidetracked down unnecessary avenues or lanes. Your time is so limited and so precious, so this requires following this preparation process ultimately so that you can be hyper prepared and use your time efficiently and credibly. Finally, you saw some tips on how to handle a really hot panel and keep calm and be polite, yet firm on getting to make your points. Advocacy as a lawyer is a wonderful thing for us all to engage with and improve on. I hope you find this program useful, and if you want more advocacy programs, you can check out the advocacy series I talked about in the beginning. As always, if you have any questions, please feel free to email me, and I'm happy to engage. Thank you for listening, and please prepare well and go win your immigration appeal.